Yes, but I would say that opinion does not deal, that is a case where there was a search warrant of a congressman's office. That congressman was a target of the investigation. The search warrant wasn't seeking non-content toll records. It was seeking the actual records, legislative material of the congressman to be used against that congressman.
Right. But, I mean, the court in the Rayburn case concluded that there is a documentary non-disclosure privilege, not just a prohibition on the evidentiary use of that material against members.
I'm not debating the Rayburn case exists. What I'm saying is in the Supreme Court or the D.C. Circuit, there is no case that says non-content. Rayburn dealt with content. Non-content records, not secured from a member, but secured from a third party, are subject to the speech or debate clause. And if I may, the correspondence we talked about, that reading, which was the reading of my staff who are very familiar with this, was consistent with the department's position on those issues, and public integrity, which was sort of the keeper of this issue, concurred in our getting these subpoenas.
We're making exhibits. We have to number 6?
Yes.
And this is some back and forth. What Exhibit 6 is going to be an email between your office and Public Integrity regarding the Senate, the toll records for the senators.
Thank you very much.
Thank you.
Thank you very much.
The relevant, these documents are helpfully not based.
Yeah. If you want to show me yours, I can look for it here. Okay. This one.
So the department has, if you're going to, has requirements for all prosecutors that, if you're going to bring a tax prosecution, you have to consult with the tax division, right?
Correct.
If you're going to bring a national security related case for classified documents, handling of classified documents, you need the National Security Division to okay that, right?
Correct.
And as it relates to, sensitive political matters, the Attorney General has to okay, and there's been a series of memos both from Attorney General Barr and Garland and so forth, correct?
Sensitive political matters, I'm not sure if that's the terminology. There's an election year sensitivities memo, and there's also regulations, specific regulations for specific situations, yes.
Right, and the FBI calls it a sensitive investigative matter, and they need to get they can't do anything without getting the director of the FBI to okay, getting search warrants against members of Congress and so forth, correct?
I'm not as familiar with the FBI regulations as the DOJ regulations.
But is public integrity, before you seek member toll records, is the hoop you have to jump through public integrity?
So it was for my office because I directed my staff to consult them anytime we were going to do that. I understand that that was more of a practice and tradition. It's since become a specific requirement after these toll records were issued, but it was my policy to do that, and it was, again, consistent with my policy of wanting to sort of leverage the expertise in the department. So we did that.
Is this back and forth, and your staff had a memo that it, I think, basically put in email, and then Public Integrity responds with this message. Is that essentially the extent of the back and forth with Public Integrity?
I don't know that this is the extent of it. I don't. There's a line here that says, "As you are aware." That makes me think that there was also a telephone conversation, but I don't. Just to be clear, I don't have a specific recollection of that. I told my staff that in this situation, if we're going to seek these toll records, you need to consult with Public Integrity. As you can see from the email chain, I wasn't on that email chain.
Were there any other boxes you had to check? Did you have to tell the Attorney General or the DAG to get these toll records, or was it just you and Public Integrity?
My direction was to tell for our staff to go to public integrity. It may well have been that this is the sort of thing either I would have briefed the Attorney General on, or J.P. Cooney, who was our contact with the leadership of the department, may have told them about. But the thing that I was most concerned about was making sure public integrity, who was the sort of the experts on this issue, that they were consulted.
I mean, this isn't, if you look at the email, it's not that fulsome, right? It's not a complete analysis of the constitutionality or even the propriety of the call record subpoenas under the speech or debate clause. I mean, is that fair to say?
Yes, certainly there could be more analysis, but again, I don't know if there was an additional conversation that, it seemed, I'm drawing an inference, I don't recall this, but this seems to me to indicate there may have been an additional conversation.
So the email, from our perspective, it seems to be a cursory litigation risk assessment. It's not, it doesn't raise the issues that we would raise if we were litigating the speech or debate matter. Because, I mean, our position is that the toll record subpoenas do violate speech or debate. I mean, if you get a list of all the people calling members of the Judiciary Committee before a floor vote, that is pretty core protected material. This back and forth with public integrity doesn't address very much. Is that fair?
Well, again, I don't know if there were additional conversation or conversations. I also don't know, frankly, if this is the only email on this issue. So I don't think I would call it cursory. I think an important context here is that the people involved in this, including the people in this email chain, as well as one of my senior counselors, Ray Helser, who is really the department's expert on these issues, that these are people with expertise in this area discussing it with one another.
But if you believe what the Washington Post reporters wrote in their book, they say, according to their sources, that you were legendary for being dialed into, every last detail of these cases. That you were, they stopped short of calling you a micromanager, but they say that, you looked at, witness outlines, 2 days before witness interviews. Is that fair?
I did that with outlines of interviews, yes.
And you had, at points, you had daily meetings with the teams, and you wanted to know, every last detail of your case. Is that fair?
I try to be a responsible supervisor, yes.
But when it comes to taking the members of Congress, phone records, you weren't as plugged into that. Is that fair?
No, I don't think that's fair. I spoke with my staff about this. I ultimately approved it.
Right.
I had faith in the expertise of my staff. They discussed it with me. I felt there was a basis for it. I felt it was relevant and material to the investigation. And I also felt comfortable because I knew that my view about that would be tested by an analysis of public integrity.
Look at the last sentence. Low likelihood that any of the members listed below would be charged, and the litigation risk would be minimal. Not to mention, they're not going to know. So the assessment is, as Steve described, pretty cursory. We're not going to charge anyone. We're not going to get sued. They're not going to know. Who cares about speech or debate? That's what the assessment looks like to me. Your response?
Chairman, I would disagree with that characterization of it.
Well, that's what the sentence says. We're not going to charge these people. I doubt if they take us to court. It'd be hard for them to take us to court because they're not going to know for years that we did this. Move ahead. And you said fine with that.
I approve these subpoenas, yes.
Okay.
And, our view is this is inconsistent with the D.C. Circuit case law, which establishes that the speech or debate protections includes a nondisclosure privilege, period. It's not just a privilege against using that material against the members. It's also a privilege against taking that information and using it against a third party. If you're going to prosecute Jeff Clark with Scott Perry's phone records, we believe that the D.C. Circuit holds you can't do that. And this back and forth with public integrity doesn't factor that in. That's concerning to us. Did you have any discussions with the Office of Legal Counsel or the Solicitor General's office? Were there any other components in the Justice Department that analyzed this?
On this discrete issue, I don't have any recollection of those entities being involved in that discussion.
Okay. And there's a statute regarding Senate phone records. Are you familiar with 2 United States Code 6628?
Yes.
And did you analyze or factor in that statute before you issued the subpoenas for the senator toll records?
As I sit here today, I don't recall specifically discussing that statute. I will say that my reading of that statute as it existed at that time is that that was a statute directed at providers. It actually envisions that a provider might actually get an NDO application, and the provider who has the best information about whose phone line is whose, that they're best situated to make these judgments.
Okay, so that was my next question, is like, whose responsibility it is to flag that there's a statute, a law, that bars NDOs with regards to certain Senate phone numbers? Whose responsibility? Is that the special counsel's office? Is that the carrier? Is that the judge? Does the judge have to sort of figure this out? The magistrate judge? Certainly the magistrate judge doesn't have to figure it out like all on his own, does he?
Well, that statute, as I said, my reading of that statute, the language of that statute as it existed at that time, is that it's the job of the carrier, and to me that makes sense because they're the ones who have the best and most accurate information about whose phone lines are whose. They actually have that information.
Okay. But the package of materials that you send off to the magistrate judge or the chief judge, whoever the duty judge, as you mentioned, you don't identify that it's a Senate phone number or a member of Congress in those applications. So there'd be no way for the judge to know that there's these additional considerations. Is that fair?
I think that is fair. I think the department guidance on that issue has changed since these events we're talking about, and so now if one were to do that, you would notify the judge.
Okay, and my time's up, so unfortunately I have to leave it there. We'll go off the record.
Mr. Smith, let's just start with the bottom line up front. One of your investigations focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
And can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island, and I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C. and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville. I left government for the only time in my career. I was in worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
I'm sorry to interrupt. Can you just speak up a little bit?
Oh, I'm
I know-
sorry.
Yeah, the people in the back have trouble hearing you.
Sorry about that.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the cases that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Admiral Louima case, which was a assault of a Haitian immigrant by police officers. I did an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11. I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened on 9/11. After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York. It sounds like there were war crimes cases, there were domestic violence cases you just described. Taking all that experience, when you finished your investigation at Special Counsel's office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump taking or willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
So we've heard a word a lot from this administration, from the majority Republicans, and that word is transparency. And yet, Mr. Smith, we're in a closed-door deposition today, meaning that members of the public and even congressional members and staff who are not part of the Judiciary Committee are not permitted to attend this proceeding. Did you offer to testify publicly before this committee?
Yes.
How did you offer, I guess, how did you make the offer to testify publicly to this committee?
I think it was through my counsel.
Did you send a letter to the committee? Did your counsel send a letter to the committee offering to publicly testify?
I think that's right.
We'll insert that letter into the record just for your background. And this will be Exhibit 7. It'll be an October 23rd, 2025 letter signed by Mr. Lanny Brewer and Mr. Peter Koski. It's addressed to Chairman Jordan and Chairman Grassley regarding Mr. Smith's public offer to testify publicly. Are you familiar with this letter, Mr. Smith?
Yes.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I work with, the career public servants I worked with, who've been vilified by President Trump and people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly because you had something to hide about your investigation?
No.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? The answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. Do you recall the October 14th, 2025 letter to you from Chairman Jordan requesting a transcribed interview?
I know he sent a letter asking for me to be interviewed, yes.
We'll enter that into the record and make it Exhibit 8.
Thank you.
And I'll give you a second just to look through it as we pass it out. So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, "politically motivated prosecutions of Donald J. Trump," end quote, and said you conducted a, quote, "unnecessary and abusive raid of the residence," end quote, of Donald Trump, and that claimed that you, quote, "manipulated key evidence in the investigation," end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No.
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who've been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions of the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
Based upon your knowledge, is it generally the practice for the special counsel who investigated presidential conduct to be given the chance to testify at a public hearing to be able to explain their findings to the American public?
Yes.
So let's just take a few of those. Are you aware of Special Counsel Robert Mueller testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in July of 2019. Are you aware of Special Counsel John Durham testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in June of 2023. Are you aware of Special Counsel Robert Hur, who came up earlier in the majority's hour, testifying before the House Judiciary Committee?
Yes.
For the record, that occurred in March of 2024. Also want to touch a little bit on, speaking of just transparency and a fulsome investigation into this committee's request for documents related to your investigation. We're going to enter into the record another letter from Chairman Jordan. This one's addressed to Attorney General Bondi. This letter seeks records related to the Arctic Frost files, and it's dated October 29th of 2025. This will be Exhibit 9. And you might not be familiar with this document, so I'll give you a second to review it. It's not very long, though.
Okay, I've reviewed it.
So after reviewing it, are you now aware that Chairman Jordan has sought the production of files related to your investigation from the Department of Justice?
Yes.
And just to read that request, it's request number 2. It says, in quotes, all DOJ documents and communications referring or relating to Jack Smith's special counsel investigation for the period of November 18th, 2022 to January 20th of 2025. I just want to get a better understanding of this broad request of all DOJ documents and communications referring to your investigation. I guess what types or categories of documents are associated or would be associated with your investigative files?
There would be numerous documents. I mean, it was a prosecutor's office, so the sort of documents you would associate with a prosecutor's office.
Just to make it clear for the record, can you just give a few examples of what those records or memos might look like or what they might be about?
Prosecution memos, email correspondence with my staff, analysis of the case, things of that nature.
Would these documents include internal decision memos or other records of major decisions made by you and your team during the investigation?
Yes.
Do these files include communications with the Attorney General or the Deputy Attorney General during the course of your investigation?
I don't think I had any files that would fall into that category. I'm not sure if there'd be, my deputy also communicated with the Deputy Attorney General's office, so there may be, but I don't think that's to me.
Do these files include communications just with other DOJ offices? I think earlier you mentioned possible communications with the Solicitor General. Would those files include possible communications with that person?
Yes.
Can I just follow up on that for 1 sec?
Sure.
You had no communications with the Deputy Attorney General?
No, I took the question to mean in terms of like email or things of that nature. We met, I met with the Attorney General, the Deputy Attorney General at times at their request. So those things did happen. I'm just saying I don't recall me having any sort of email communications with either of them.
But in terms of the special counsel offices, just following up Mr. Golden's question, the office as a whole, if there were email communications between members of your team and the Attorney General or the Deputy Attorney General, would that probably be a part of your special counsel case files?
Yes.
And as far as you're aware, the current Department of Justice has full access to your documents and memos and files from your investigation, is that correct?
They should.
In fact, you reviewed those files in preparation for your appearance today, right?
Yes, we were given access to a computer that had files on it. I can't say that it's all the files, but we were given access to that, and I reviewed that in preparation of today.
Did you follow DOJ protocol in your decision-making, including consulting with relevant offices like the Public Integrity Section, the Office of Legal Counsel, and any other entities as required and encouraged by DOJ policy?
Yes.
Were there examples where these consultations were memorialized in writing, either before or after you met with these offices?
Yes.
So given the majority's claim that the investigation was biased, do you think the case files would help eliminate some of the majority's questions about the actions you took while special counsel?
I have no objection to people looking at the case file.
To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so we can understand why certain investigative steps were taken?
I'm going to leave that to others to decide. I'm here and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
I also just want to note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
Apologize, we've got a lot of letters here, so.
Take your time.
Just don't have a lot of evidence
Here you go.
that's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
Okay. So on the bottom of page 3, I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay. So given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
We're gonna, I believe we're on Exhibit 10 now. We're gonna move on to Exhibit 10, which will be your special counsel report, Volume 1, dated January 7th of 2025. I know this is a document. I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, you provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
So to the best of your knowledge, do you recall Special Counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall Special Counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall Special Counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General, you also recommended that volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When, as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
If we're just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood your question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
You went through your extensive experience as a prosecutor. Do you believe that Mr. Nauta and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to volume 2?
Well, there is an order of Judge Cannon, an injunction regarding volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not looked at volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing, or and people can point me to a public filing, or in I think the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information, I do not want to. I want to be clear. I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So before we get to Ms. Jayapal, I just want to clear up two things. One, so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted in your career?
That I've handled or supervised others handling, I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice. And as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat, where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Let me go to Ms. Stratford.
Can I just, one thing on volume 2 before we go? It's obviously a case related to classified documents. Without getting into the detail, how was it constructed? How was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed. And so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately I don't think I can answer.
Okay, again, I'm going to go to Ms. Jayapal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena. But you had requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.
And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the attacks, the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly just on the witness intimidation issue? As I understand it, you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's